Thank you for tuning in to this edition of Legal Insights. Today I'm going to talk about purchase and sale agreements and the purchase of property, real estate in specific. As most of you know, when a house is put on the market for sale, it's generally listed by a real estate broker with what's called the multiple listing service. And that is usually available online for people to take a look and see what houses are available and different statistics about the house, the square footage of the interior of the house, the size of the lot of land, how many bedrooms, how many bathrooms, how many garage spaces there are. You generally, as a buyer, would then go to a real estate broker to act as your broker when you go to see a property. So your broker deals with the listing broker in terms of presenting an offer once you decide that you're very interested in a house and you want to buy it. An offer form is then prepared by your broker, and in that form is listed the different the purchase price that you want to pay for the property, the amount of down payment that you're going to have, whether you're going to have a mortgage and what the date is to get a mortgage, what the date is to sign a purchase and sale agreement, what the date is for an inspection of the property, which is very, very important. Once you have your inspection, generally you know whether or not the price that you offered for the purchase of the property is going to be adequate. In other words, if there were certain things that showed up in the inspection that need to be repaired or fixed, you might want a concession from the seller. In other words, a price reduction so that it will compensate for these items that need to be fixed. There are some sellers who say, you take it as is, I'm not paying anything further, or I'm not going to deduct anything further. It's up to you to decide whether or not you want to go in that direction, or you want to look for some kind of either concession on the price or list different items that need to be fixed by the seller before the purchase can go through. Once you've agreed on all that, then generally the seller's attorney or the listing broker prepares what's called a purchase and sale agreement. And that's the legal contract between the buyer and the seller, and sets out more specifically the terms and protections for each party. And that's a very, very important contract. Once the parties have agreed on the purchase and sale agreement, then generally the buyer will take that agreement to their mortgage bank or mortgage banker and apply for a loan. And this date and time, things usually take, I would say, 35 to 45 days at the least to get what's called a mortgage commitment. In other words, the bank is saying, yes, we will give you the loan. It's not a pre-approval. This is saying we really will give you the loan, and these are the terms we'll give you the loan. It'll list the amount of money that the mortgage loan is going to be for and different conditions that you have to satisfy for the bank in order to get your loan. And sometimes there are some very intricate conditions that are listed on that commitment letter. You have to make sure that these are conditions that you actually can meet. Because if you can't, then you don't really have a strong commitment, and it might be time to bow out of the deal. So you have to make sure that the terms are such that you can meet the terms, that you can provide the information in an appropriate amount of time so that the transaction can then proceed. Well, let's assume that you get to that stage and everything is fine and you've submitted everything to the bank. Then what happens is you have to wait for what's called a clear to close from the bank. And that means that the parties who are preparing paperwork at the bank's office have enough time to prepare that paperwork and get it to the closing attorney so that the closing can take place. A lot of banks need anywhere from 48 to 72 hours after the clear to close in order to provide the appropriate paperwork to the closing attorney. Once that happens and the closing attorney gets the paperwork, the papers for the banker and the closing are then put together and prepared for the actual closing. And all those papers are sometimes can be voluminous. They could be anywhere from 20 to 70 pages of paperwork that are necessitated at the closing. The primary documents are the settlement statement, which is a breakdown of the cost and expenses, the mortgage, which is the security for your promise to pay back the money you're borrowing from the bank, and that gets recorded at the Registry of Deeds, and of course the promissory note, which is actually the contract between you and the bank to borrow money and to pay it back to the bank under certain terms and conditions. Most buyers want what's called a fixed rate loan so that they know that for the next either 15 or 30 years, the rate is going to be fixed at a certain percentage rate and that their payments can't go up or down. That's why it's called a fixed rate, and that is preferable. However, if you know you're only going to be in the house for anywhere from 5 to 10 years, you may want to get what's called an adjustable rate loan. And an adjustable rate loan, after 5 years or after 10 years, the rate could change. But that won't make any difference to you if you know you're going to be selling the property in 5 or 10 years. The benefit of that adjustable rate loan also is that the rate is lower because the banks know that they're not stuck for 30 years on a specific rate. So it's much wiser, in all honesty, to get a fixed rate if you're going to be in the property for a long period of time, and to get an adjustable rate if you're only going to be there for a certain period of time. That's a lot less than 30 or 15 years. Now it comes time for the closing, and you show up at the closing as a buyer, generally with your attorney. Sometimes your attorney can also be the settlement agent for the bank. And then the seller generally will either show up by themselves, they'll show up with their attorney, or they will give a power of attorney to their attorney to conduct the closing. Closings usually take anywhere from an hour to 2 hours, depending upon if there are any issues at the closing. Once the closing is completed, the bank attorney, who is conducting the closing, then sends the paperwork out to what's called the Registry of Deeds to register the deed and the mortgage and any other documents that need to be recorded at the Registry of Deeds. Once that occurs, then the seller no longer owns the property and the buyer does own the property and has the opportunity to occupy the property, take the keys, move in, and go on their merry way and have a happy life. That's basically the process of buying and selling properties in Massachusetts. This has been another edition of Siegel's Legal.